I've got Dave Krieger sitting next to me. He's written the book Clouded Titles. And why do we have Dave on? We just had him on last week, and this is a big deal. There's over 1.4 million homes in foreclosure right now. And there's a foreclosure map. That's just in 2008. And that's when everything just started heating up. Take a look at Michigan and Wisconsin, and then you have California, Arizona. Now, this is today, as of March 2012, a lot more homes going in foreclosure than were back in 2008 when we had the financial crisis. So we turn now to Dave Krieger and welcome him to the show. Dave, how's it going?
Welcome, Rob. Thank you.
Right. Thanks for coming on. Again. Yeah, it's great to have you on. This is a big subject that a lot of people have been talking about. You were telling me earlier somebody contacted you from Australia.
As a matter of fact, your show has huge reach, and I was totally blown away when I opened it up and I was getting questions about what's going on. And she says, well, I understand securitization. Could you explain a little more? Does the chain of title work the same way in the States as it does, in Australia as it does here? I said, in theory, there's a lot of things in the book that make sense. But as far as, equating this with the Commonwealth, this book was basically written for U.S. citizens or residents or whatever you want to call the little 14th Amendment.
Our foreclosures go counterclockwise down the drain. Theirs go
exactly the other way. It depends on if where the shark is on the Great Barrier Reef. But they basically they do have securitization over there, and they do have any time that there's a securitized note involved, there's a pooling and servicing agreement, and I talk about this heavily in the book.
Yeah, that's a big question because I've closed on 2 pieces of property. It is a crazy process. They take you in a room and they just throw paper at you to sign, and you really don't have time to read it. I read the first 2 documents and I could just feel them tapping their foot. I was like, just hurry up and just go through the process. You need to sign these documents so we could pay the 15 people who are in the feeding line.
How about the one that's, well, I have a closing in 15 minutes. I got another closing, so we have to hurry up.
Yeah.
They think, well, you just want the keys anyway, so here, just sign these documents and sign your life away.
Right.
And you have no idea what you're signing. And a majority of the people that actually buy this book, and it was written for them. I have a lot of people that actually write me, and they call this their Bible.
Yeah.
And literally, I have people that have tabbed it and highlighted it and taking it into different sections so they can, try to get their hand around and understand exactly what's going on, because this is a massive subject. And, when you're talking about foreclosures or deeds or chain of title, and it depends on who I'm talking to. The conversation shifts in 15 different directions depending on the need, because everybody's got different needs.
Right.
And most of the homeowners that are involved in this were sucker punched in 2003 when this whole fracas first started.
Right.
What ended up happening was that they were told, well, home ownership is where it's at in America. America is prosperous. America is great. Everybody needs to own a home. So here's what we want you to do. The banks all of a sudden opened up the floodgates and made credit just available.
They have first-time homebuyer programs, everything. There's all kinds of programs.
And program, there's the key word. What was going on behind the scenes, Rob, is they were taking, and they had all these securities set up on Wall Street in trusts. We call them SPVs, for special purpose vehicle, or SIV for special investment vehicle.
Okay.
And so what happens is they have all these notes in the pool, and they're all there assigned, and all the borrower has to do is go to closing and put their name on that deed of trust or mortgage.
Wow.
All of a sudden, you'll notice, because MERS is involved, and we'll talk about that. MERS, M-E-R-S, is an acronym for Mortgage Electronic Registration Systems. This is a database, in essence, that was started because people say, well, where did this MERS come from? MERS started from Fannie Mae, Freddie Mac, the Mortgage Bankers Association, the American Land Title Association, and all the major banks. They all jumped in. MERS has now over 5,500 members. And
who are the members in MERS?
All the major banks and the servicers. There's like 3,300 servicers, which are the people that are actually taking the mortgage payments for your loan.
Okay.
So people starting out with Clouded Titles 101 first need to understand that what the mortgage bankers did was they set MERS up to do nothing but track the transfers on Wall Street between all the sales that were going on. If you look on your deed of trust, and I tell people to do this, get out your specs, put them on, and look at your files. Get out the deed, get out the mortgage, look at what you got, look and see whether you see that little MIN number, that MIN, MERS identification number. See if you have that MIN number on your document, because it'll be right there next to the document title where it says mortgage or deed of trust on page 1. It'll be there.
That's like the Social Security number for
of
the
securitization, because the intent was to securitize the loan.
Right.
Right out of the gate. Now, they never told the borrowers this.
No. They're going to go out and make money on your mortgage,
Exactly, and there's so many theories floating around right now. There's a theory where the what happened was the lenders went in and they borrowed the money from the Fed at a cheap interest rate.
Of course, yeah.
And so they have this money, and what they needed is the borrower's signature.
To release the money.
To release the money.
Yeah.
So the borrower signs, gives up their personal identifying information, their social, where they live, their job history, everything, whether it's fabricated or not, because we know that in 2003 through 2008, there were ninja loans, which is no income, no job, no assets. There were liar loans, basically stated income. Just put down whatever. Well, let's tell you what. We'll make something up and we'll dummy up your financials to make it look like you can afford this $500,000 house. When in effect, you should have had a house that cost $50,000, not $500,000.
Right.
You could only legally afford to pay this much. Well, back in those days, it appears unconscionable that they would do stuff like this. And so they basically sucker punched people at the closing table, and they had them sign these documents. And here's this money that's coming out of the Fed, out of the Treasury. And so what's happening now is the investors that are coming in through Wall Street, and they're looking at these 424B5 prospectuses. Now, these prospectuses have all these documents inside of them, like the pooling and servicing agreement, which shows you all the terms and conditions for the trust.
Right.
So people, they have no idea this is going on behind the scenes. They have no idea that their own 401ks that they've been putting money into on their job are being used and pledged into these trusts, which have loans in them that are structured to fail.
Of course.
And so they're playing both ends of the coin with the banks as the middleman. And so once that investor money comes in, what does the bank do with it? Pays off the note. So the note is paid in full. The note you signed is paid in full. That's one of the theories that's floating around right now that attorneys are trying to get discovery on.
And then they take the money you send in and use that as leverage to buy
Exactly.
whatever?
And a lot of it gets shaved off in what we call a yield spread premium. And so that's something that's totally different than most investors understand and most brokerages understand. But, you know, long and short is they have an aggregate fund manager that has all this money coming in from all these investment pools. And so all that money gets spent. Now, when you are an investor and you're expecting to get a return, and we start looking at these documents in the chain of title where an assignment has been recorded, and when they record the assignment, it's dated years past the date the pooling and servicing agreement says it should be put in the pool. So if there's a cutoff date on the trust of September 30th, 2007, and the document, the assignment isn't recorded until 2012, well, they just missed the trust pool by 5 years.
Wow.
And it violates New York trust law. And a lot of the banks, they want to come into court. They don't want that PSA getting introduced as evidence because then the real truth will come out.
Yeah.
And see, judges are now starting to figure this out. They're starting to understand, because MERS's own CEO, as we commented on Alex's program last week, we commented the fact that, you know, when you split the deed from the note's a nullity, according to Carpenter versus Longan, which is an 1872 Supreme Court case out of Colorado. You have to keep the note and the mortgage together. They just ruled on this in the Eaton versus Fannie Mae case in Massachusetts. This just came out, and of course now wasn't made retroactive because that would have unleashed a firestorm of lawsuits. So what MERS has done basically, according to the accusations that the attorneys are making in court, is they've obfuscated the chain of title. When it goes into the MERS system, you have no idea who owns the note. It gets sold and resold and resold, and if you look at your mortgage or deed of trust in the long form, which is like a form 3043, 3044, 3048, they're Fannie Freddie uniform instruments with MERS. And if you look at paragraph 19 or 20, clause 19 or 20, under sale of note, change of servicer, this is what gives them the license to take your note, split it off from the deed, and run with it. And so they're out there on Wall Street selling this note. It's been paid over and over and over again. And because it's tracked on the MERS electronic database and never recorded in the land records, you have no idea, not only who doesn't, you have no idea who owns the note, but also the assignments are never recorded.
There's no chain of custody going.
There you go.
Yeah.
And see, when you're looking at the chain of custody of the note versus the chain of title, they're in two totally opposite directions. You have no idea, and this is why we do chain of title assessments, because that's one half of the equation.
Right.
And so we're training people to do what I do. I have attorneys calling me from all over the country, Rob, and they're asking me, look, would you look at this person's title from the warranty deed forward and tell me what's wrong with it? And I've actually, attorneys have literally just missed these things. This is what I train people to do, is to, you know, put on the eagle eye and spot the problems. And
now, going to your seminar or getting the book, is this for people who are thinking about buying property or have already bought property, or, you know, is it, if they're already getting foreclosed on, is it too late for them to start learning these things? Actually,
I have a lot of people coming to this upcoming CODA seminar in Chicago, the workshop, and a lot of them are being foreclosed on. I had a woman in Las Vegas today, and she's coming, and she told me, I've lost millions of dollars in real estate. I own a lot of rental properties. And she says, I want to learn what's going on here because I have a sneaking suspicion that I've got, you know, a pretty good case on a lot of this stuff. And I said, well, you might. I said, the saving grace about Nevada is they just passed Assembly Bill 284. Lenders can't just come into court willy-nilly and file all these documents. They have to attest to the validity of the document, and if they don't, it's criminal.
Right.
And they can actually get jail time and get disbarred. So this was a huge thing in Nevada, which, by the way, when you looked at that 2012 foreclosure map that you were showing on there, you see what we call the sand states.
Right.
This is where the biggest hit was taken. If you notice, in 2008, which is what you're looking at right now, you'll notice that Southern California and Nevada, especially up in Vegas, Reno, all up, you know, and when you go through the, like Florida, Florida, Arizona, Nevada, and California are what we call the sand states.
Right.
You'll notice how much pink is in there and how it was hit in 2008. Well, as the jobs started to diminish, if you go to the 2012 map, look at this. Now you look at the Rust Belt up there in Michigan and Iowa and all those places in there, you notice how all of a sudden there's big clusters of foreclosures going on. We're looking at another 4 million foreclosures in 2012, and it just keeps growing and growing and growing.
It's an epidemic, and a lot of this is people were duped into these. They were given, and now we've learned that the interest rate that everything's based off of is false as well with the LIBOR scandal.
Exactly.
So it's just scandal after scandal after scandal. Let's get into robo-signing, because that's another part of this where you have people signing these titles who aren't licensed to sign them, but they're just signing them for somebody because there's a glut of these things that need to be signed. Is that, am I getting that right? Or
basically, the term robo-signing was coined by, you know, there was a handful of attorneys that started doing depositions of these people that were assigning documents. And when they looked at the assignments, they basically said, well, you know, what's wrong with this picture? Because here we have an assignment from this person, Linda Green, and she's signing this document as vice president for Wells Fargo.
Right.
But then we turn around and we have the same address and same zip code and same people preparing the documents, and here's Linda Green signing again, only this time she's signing as vice president of Chase.
Yeah.
And so it's like, well, wait a minute, the two Linda Green signatures are markedly different.
Yeah.
And so this is another term, what we call surrogate signing. This is where they have, and they actually did admit to this, they have signing rooms in places like the now defunct DocX or Docs, D-O-C-X. And if you happen to be going through your assignments in the land records, ladies and gentlemen, and you happen to see the name Ronald Mayharg on the top of your paper in the upper left-hand corner, and you look down and you see DocX or DOCX, all of a sudden, red flags should go up, because the people that are doing this, these people were document manufacturers, and what we're finding out that they did, it appears that they have one room full of people. All they did was sign their names to documents, 350 of them an hour.
God.
And they're paid $10 an hour to sign as vice president of some bank, and we don't even know, you know, when you ask them in deposition, you know, where is the authority that you have to sign these things? Do you have a power of attorney or some signing authority that's been giving you, you know, power to sign your name as vice president of these? And a lot of them are signing them as vice president or assistant secretary for MERS.
Wow.
And what they're doing is they're conveying the note, and a lot of these cases are saying that MERS doesn't have the authority to convey the note because MERS doesn't have an interest in the note. You can only grant what you have an interest in. And according to the contracts you signed at closing, which was your deed of trust or mortgage, you only gave MERS the power to be the beneficiary on paper. And what that does is it creates a static condition in the land records, according to the way that we are looking at their business model. And it appears that this static condition basically will suffice for all the transactions that are conducted outside the recorded system that we know it. Right. You know, this system started back in like 1600s, 1638 in Plymouth, you know, in the Massachusetts Bay Colony. I mean, this thing is as old as this country. And, you know, we've relied on this, and the judges are even starting to turn an eye to this stuff and say, you know, there's something really weird going on here, and if you don't give me the entire chain of title, I don't know exactly how you got it, Mr. Lender. And so this is where we're having, you know, big issues in court. There's just, the robo-signing thing is literally touched off a firestorm of depositions. And we have robo-signers here in Austin, Texas, that are being called on the carpet. One signs as a signer, as vice president of One West Bank, but then they were, of course, you know, taken over by IndyMac Bank, and the FDIC was the receiver. And before, we have the same person signing as a vice president of IndyMac Bank. Yeah. And it's like, and then she admitted in deposition, she never even read the document. She never even knew what she was signing. And then we asked, you know, the attorney asked her, and where is the notary that supposedly witnessed this document? Well, the notary's in another part of the building. So when we go into depositions, when we consult attorneys, we ask them to get a copy of the floor plan of the building that the person signing these documents sits in, because then we can say, okay, now where does the notary sit in relation to you? Because Texas law clearly says the notary must be present when you sign the document, and you must sign their logbook. They are required to keep a journal. Okay. So when we go into deposition, we say, okay, where's your journal? You know, the attorney would literally say, I need to see the journal. You know, show me where in your journal it says that you witnessed this.
And defense says there's no journal. There's nothing there.
And they say, well, we're not required to keep a journal. Well, excuse me, Texas law says you are.
I just went and got a document notarized at a bank, and they have a journal. And they put a stamp on it.
And they made you sign it, didn't they?
Yeah. And that's the way it goes. It's a proper paperwork procedure, as they say.
Exactly.
And so let's go into what this means for I guess the housing industry in the future. What is going to happen when the dust settles on all this? Are people going to, if you bought a house, say, can 10 years later somebody come back and say, hey, that wasn't done right, that's still my house? Is that going to be happening in the future?
It is happening.
Oh my God.
And not only is it happening in that regard, but it's also because of the MERS system, we are seeing a lot of cases where homeowners who thought they paid off their house are being subjected to double liability.
Right.
In other words, a lender is coming out of the securitization system and saying, hey, I had an interest in this, and as far as we know, we still have an interest in this property. And they're saying, but we paid it off 6 years ago. Well, we don't care. We're the servicer for this investor, and this investor says he owns it, so we're foreclosing. This has literally touched off a firestorm of lawsuits across the country. People buy short sales. 2 months later, Chase Bank comes in, forecloses on this guy, cleans out his entire house, winterizes his toilets. He has to break in the basement window to discover all his heirlooms are gone. Everything's gone. He has a lawsuit against Chase. They break into some woman's house in Pittsburgh, Pennsylvania while she's at work. They steal her pet parrot. Go figure. She has to drive 2.5 hours to get her parrot back, but all her furniture is cleaned out completely. They've winterized the toilets. She is not in default on her mortgage. We have people that the banks have foreclosed on when the banks don't even own the loan.
Right.
It's that crazy because the left hand doesn't know what the right hand is doing, especially when you're dealing with a servicer and a trust entity and a bank. And everybody's getting different information, and it's coming through what we call a third-party document mill. And there are identified third parties that we talk about in the book, like lender processing services, like CoreLogic. They have a document solutions in Chapin, South Carolina on Boundary Street. We watch their stuff, you know, because we're seeing documents come out of there that are generated by people, and they're using addresses we know are phony. And so we actually have talked to the leasing agents at these addresses, and they say, no, MERS has never been here. And we have documentation. We know who to go depose.
Right.
The paralegals that I work with, because we formed DK Consultants LLC for a reason, and that was to actually assist counties in land record audits. And starting in October, we're actually auditing a county in Central Texas that literally is looking at the behavior of one specific attorney. Because they have them organized, all his signatures are organized by notary, because all the notaries on this document, this stack of documents, look the same as far as the attorney's signature. But when you look at what this notary's doing, all the attorney signatures are different from this one. And when you go to the next stack, and there's 6 different notaries there, and they've got the same attorney's signature all the way down the line, and all the notary signatures compare with each notary that's signing these things, like the notary is surrogate signing his name and then stamping it. So you got to wonder whether the attorney is present at the time these things are being signed. I think a grand jury would like to know that.
Well, and you got to wonder how people could just do this openly and blatantly over and over again and not question it and not even whistleblow on it. How did this stuff start coming out? It wasn't people whistleblowing.
It was, as a matter of fact. There were a lot of whistleblowers, like Lynn Zamoniak, who's a fraud investigation attorney in the middle of Florida, near Jacksonville. And she actually blew the whistle and was on CBS 60 Minutes.
Oh, she was in the
Scott
60
Pelley.
Minutes piece.
And I was there with her when that aired. We had a big party, and there were a lot of homeowners there that were being foreclosed on that are right in the middle of foreclosure issues and had hired attorneys. And we watched this, and it was hard to hear because everybody was screaming at the TV because they knew what was going on. They've had this happen in their own cases, and you just about cry looking at the sadness and the scope of this and how deep it goes and how much of an issue there is with the chain of title versus chain of custody of the note. And so, you know, the reason that I started doing these CLEs for attorneys in the seminars is to get people up to speed because, frankly, folks, I can't do this all by myself. So I'm willing to share the wealth and teach people how to make a good living.
Right.
And that's why we started the CODA workshops.
Excellent. You know, you mentioned that 60 Minutes thing. I found an article from recently. A Jupiter Farms family says they're robo-signing victims' house to be auctioned. And they watched that 60 Minutes piece. They went around, did their own homework, found out they were part of this robo-signing thing, but it didn't matter. They still got foreclosed on. They had to, their house got auctioned. So, like, if somebody's in this situation, what can they do if they figure out, hey, I'm being robo-signed on? Is it? I mean, how wet do you have to get in order to get your house back?
Well, you seriously, and this is one of the things, you know, we talk about in the book under Section 3, it's called strategic default. And in this particular section, I put it in here because I'm going to be honest with you, Rob. I walked away from a mortgage in 2003. I walked away from the house.
Yeah.
I packed it up. I called the bank. I says, here, it's yours. Take it. I can't sell it. I'm upside down.
Right.
They have new build jobs going on in the same subdivision that I'm in, and I can't sell my house because they can buy a brand new home cheaper than what I can sell my house for.
Sure.
So you know what? I've had it. Nuts to this. And at that time, you know, my mortgage payments were only $900 a month.
Wow.
Total between the first and the second. And they ended up selling the house and getting all their money out of it. But the thing is that, you know, when you're looking at issues like this, a lot of people are doing this. They're looking at this book and they're using it as a tool, and they call me and they go, well, should I stop paying my mortgage? And I'm like, look, I don't even know of an attorney that would answer that question without getting himself in trouble.
Right.
I said, I can't tell you what to do. You know, that's why I wrote the book. I said, because if there's something in there for you, any little nugget that will help you make a decision, it's on your conscience.
Right.
So you basically have to decide whether or not you're going to fight or flight. If you're going to run, then restructure your life. This is what a lot of people have been doing. They've been staying in their houses, literally hiring an attorney to do nothing but stave off the wolves.
Right.
And so they'll stay in their house for a year and a half, 2 years without making a mortgage payment. They'll pay the attorney a mere pittance of what their mortgage payment is.
Sure.
They will take all their money and accumulate it and then go somewhere else and buy for cash. Or they'll rent. You know, a lot of people that did, you know, we've talked about this before because I'm not totally, I understand the purpose of banks and why they're there, and not all banks are bad. I have to say that. You know, it's not a disclaimer, but I happen to know I work with some good banks and banks that do care. I actually talked to a bank's attorney when I asked him, can you fix a chain of title that's been totally trashed by this kind of a scenario? And he said, absolutely not. You cannot fix a chain of title other than to quiet it. And that's why we have what we call quiet title actions.
Okay.
And this is where you go into court and you basically put it out there to through publication and by direct service of the people you know and publication for the people you don't know. And you use the quiet title action to bring everybody into court. And a lot of attorneys are coupling this with a declaratory judgment action, which basically puts the burden of proof on them. When they come into court, they have to actually prove that they own it.
Right.
I got the paperwork right here, Your Honor. Which
is what people weren't doing before. They were just not answering the mail or doing anything, and then it's a default judgment. And then it doesn't matter if you were right or wrong. The judge is going to give it to the bank anyway.
Exactly. Well, and see, if you don't fight and you don't get an attorney and get in the game, you know, the chances are not, you know, they diminish as far as your success rate.
Right.
I know a lot of people that have gone in pro se and have done pro se litigation. In fact, I just saw a ruling out of California today on a specific situation where the plaintiff homeowner actually won a judgment. And it was not a default judgment. It was a summary judgment against Fannie Mae. And they couldn't prove that they owned her paper. And the judge literally quoted Carpenter versus Longan, that 1872 case that says when you split deed from note, it's a nullity. Some judges understand this. It's so simple. But other judges, we have to actually look into their financial records and find out whether they own any bank loans. We had a judge in Palm Beach County, Florida, that had a massive Bank of America portfolio, and basically her retirement was in Bank of America.
Right.
And so here she's sitting on all these Bank of America cases. Go figure.
Right. Well, and that, after I'm looking at all this stuff today, Bank of America seems to be in the thick of this mess. They seem to be, my house loan, my current house loan, I didn't sign with Bank of America, but all of a sudden Bank of America is sending me the bill. So they're going out and reaching out and grabbing people's loans. I guess they're buying these mortgage securities that are out there, and then they're becoming the mortgage holder at that point.
Well, a lot of
how do they do that?
We're still looking at how they acquired these, because if the trusts went bust, if they went into default and the investors lost their money, what they're doing is, because of the fact that there is a 424B5 prospectus that is issued, and what this does is it contains all the information about the trust. I call it a poop sheet. And basically, you look at it, it's got the PSA, the pooling and servicing agreement on there. It's got all the terms and the distribution date. Tells you when the cutoff date is and when all the notes have to be in the pool. Has a closing date for when everything gets finalized. It has a distribution date, which is usually 30 days after the closing date, when the investors can expect to get a distribution of funds.
Right.
There are, anybody that's been playing in these things and realizes that they've been duped, if they're an investor, what they're doing now is they're coming back and they're suing the bank, and they're saying, hey, you lied to us on the prospectus, and we bought non-recourse bonds, which means they're powerless to come after the homeowner. They're powerless to do anything. All they can do, and what they've been doing, according to the research, is they've been going after the lenders and saying, hey, this, the brokerage house is saying, this paper you sold us, this was fraud. This whole thing was fraud. You misrepresented, you lied to us on the prospectus. None of this stuff you're saying on this prospectus happened. And so what the banks are doing, who claim to be buying this portfolio, are giving the investors back their money at 10 cents on the dollar. Wow. And this is your 401k, folks, that went down the toilet. It's gone. And this is why you see, when you look at that foreclosure map, you see all of these shaded areas that are just, you're looking at 4 million potential foreclosures this year. When you look at that map for 2012, this is huge. When you take that and you extrapolate it and you run that map a little further into the year, you're going to notice it gets a whole lot darker.
Well, and I think a lot of this great area is probably government land.
Well,
most of that's government, Montana. A lot of that's
up in that area, there probably is a lot of government land. But the thing is that they control all this, and the banks, I think, are waiting and trying to stall off a lot of these cases. They don't want bad case law. What they're trying to do is trying to get themselves set up to where, because they think the government will jump in and rescue them.
Right. Well, and they have laws that they're trying to get written where retroactively they didn't do anything wrong.
Exactly.
At that point, we don't have to have chain of custody. We don't have to have the things that we've had in place since Plymouth Rock. All we have to do is say, well, it's okay now, we're going to wash our hands and move on.
And this is a problem, because the thing is that most states right now, this could come down to an issue between states' rights and all the county clerks that are running the land records. When I first shared this information with the Texas Clerk School in January, we had 200 clerks come to attend this out of the 254 counties. The second session, which they were only 50 minutes long, but it was MERS 101, and I was explaining how this whole system came about and the robo-signing and everything. And when we first started out, I had 100 clerks in the second session, and I said, who here has heard of MERS? 100 clerks in the room. 3 hands went up.
Wow.
3 hands. That's exactly the words that came out of my mouth. Exactly the words that came out of my mouth. I went, whoa! And then I said, how many have heard of robo-signing? 1 hand went up.
Yeah.
And I'm like, oh,
kept in the dark and the mushrooms.
You're in for a real treat, clerks. You're in for a real treat. The problem is that they don't understand the nature and scope of how deep this goes with chain of title. And one of the things that is now coming to light with a lot of these judges, a lot of them refuse to issue summary judgments and orders when the chain of title is not clear. And so homeowners literally, with their attorneys that have gone into court and said, we have an issue with chain of titles, it's put the brake on the entire scenario, on the entire foreclosure.
That's a good stall tactic.
Well, my mantra is, if I can't convey, neither can they.
Right. Oh, okay.
That's my mantra. Good. It's always been my mantra. I put it in the book. If I can't sell this property, Your Honor, then the problem I have as a homeowner is if it's uninsurable, I can't sell it. Right. If a title company like we had some inside information from one of the big title companies in Kansas City that 1/3 of the properties that were mortgaged or refinanced between 2003 and 2008 are uninsurable. That means that they can't get title insurance and they can't sell the house.
Right.
If they can't do it, how can the bank? How can the bank turn around and foreclose and sell that property?
Well, banks are special. We have to give them money when they fail. You know, these are special creatures. These people need lots of money to live, all these bank executives. You know, and it's sad when, you know, one of the HSBC heads jumps off a building because he's probably involved in some fraud scandal funding Al-Qaeda. I mean, it's amazing that we coddle to the banks over and over again instead of actually holding their feet to the fire. These are rules that they're supposed to be playing by. Well, they're supposed to be the professionals.
And see, we have a lot of investors attending the CODA workshop. And by the way, you know, this is the workbook that I give you at the workshop. It's 200 pages, and we actually have in here case studies. We actually go into detail, and we show you the difference. We show you the stamps.
Here, let's get this. Here, we'll put this on the overhead cam right here.
So you can see this. You'll notice in here where we're looking at specific issues, and we actually show you how to read these document stamps and how they are formulated by index. And so, you know, we actually, when we put this thing together, we show you in the workbook how this whole thing is set up. And we show you in here, you know, what happens, and we ask you to look for certain things. We show you, you know, that it was a countrywide loan. We actually take you through the entire structure, and if you look right here, you'll notice a document ID number. But what's this?
There's your MIN number.
There's our MERS identification number, our 18-digit number. You can actually go to the MERS website and take this number and input it into the website at MERS, and you can actually find out who the servicer is, but only if you have your Social Security number. Now imagine that. How did MERS get your Social Security number? Well, when you agreed to make MERS the beneficiary, you gave MERS the permission to take your personal identifying information and run it all over Wall Street.
Oh my goodness.
Now who knew that? Who knew?
Yeah,
Who knew that you were going to get shellacked like this? And you know, frankly, the borrowers were never told that their loans were going to be securitized and put out to Wall Street. It's like the banks are saying, well, that's none of your business.
Well, you should get a percentage of that if they're using your money.
You would think that if the note was paid off in advance, that paid off money would be applied to the borrower's mortgage.
Sure.
That's not the case. So we have the scenario, the theoretical scenario, that they're borrowing money from the Fed, using investor money to pay off the Fed, so what the borrower signed and agreed to is paid in full. Then they're turning around and taking the investor money and investing it and pledging the same note over multiple pools, which if I did that and I pledged my house to several banks, I would be in jail. That's a felony.
Right.
You know, but the banks did this.
Banks
they got away with it because they're unregulated, and this is when they repealed Glass-Steagall back in 1999 through, thank you, the Graham-Leach-Bliley Act. You know, if you want to go in there, and I can tell you that Phil Gramm right now, you know, if I was Phil Gramm, I wouldn't be making any comments about, you know, what their intent was, because this is getting uglier by the minute, and homeowners are starting to rear their ugly head. And the more and more people that read this book and start talking to counsel and start researching their land records, I actually, when we did the CLE in Austin in May, Rob, I had investors attending this workshop because they're studying these things. Before they go in and buy a house, they want to know what the chain of title looks like. And so they're studying condition of title.
Right.
They don't want to make the same mistake, because if they buy an REO or a short sale that lender doesn't own and subject themselves to double liability, or in the case of one of the buyers, she paid cash, $60,000 cash for a house on acreage, and come to find out, the lender didn't record their interest in the property till 9 months after they gave her a special warranty deed. She didn't legally own the house. Wow. That's the take by the attorneys. And the attorneys are going, we can't quiet title. You don't own the property. You can only quiet title if you can prove you own it. So she has a whole different set of circumstances. This is how nuts this is getting. So you have 70 million potential problems that, you know, what do we have? 100 people maybe in the United States that do chain of title, if that.
Yeah.
I mean, this is literally an open floor plan for anybody that is creative. And we actually teach you in the seminar how to market yourself and get yourself out there, and how to network with attorneys and get in good graces, and how to understand what constitutes unauthorized practice of law. Because the last thing we want is for the state's UPL committee to come after anyone because they said something they shouldn't have.
Well, and you put that in the book. You put, you know, this is legal information. It's not legal advice.
That's right. You can't. I can't give you legal advice. I'm just a paralegal and a journalist.
Right.
But, you know, I've talked to enough attorneys, and I put what they said in the book. Because what the attorney tells me is one thing. What I find in research is something totally different. And I basically leave it up to counsel. There is a forward in here by the former Ohio Attorney General, Mark Dan, who is in my network, and we talk a lot. Mark Dan and I have spoken on stage together in front of crowds of homeowners, And I'll tell you what, that man is like a magnet. I got a phone call yesterday from Taj Johnson, who's another attorney in Chicago. This guy's unbelievable. He studied at University of London in London, economics.
Okay.
The guy's incredible.
Yeah.
When you look at attorneys like him and the attorney I work with in Dallas, Wade Cricken, all these people are putting themselves at risk because the banks don't like people that come out. In fact, one foreclosure mill tried to hire the attorney I work with in Dallas. They tried to hire him away.
Sure.
And they'll come to you and they will pay the attorney off so he'll never litigate against him again.
Right.
This is how they do this. They're not beyond this.
Yeah, of course not. I mean, they've most of the drug money is laundered by these major banks. I mean, it's been proven. And they pay small fines. They don't ever, if I go rob a bank, I get put in jail. They launder millions and millions of dollars of drug money. They pay a fraction of that and a fine. Billions. Yeah, exactly. It's
exactly.
billions.
Well, remind me to send you the Credit Suisse indictment because right now they're working with the DOJ, and Credit Suisse was accused in this indictment of actually laundering money from the Iranian state banks into this country. They would literally change the bar and the transit codes and change the routing numbers to get that money in here. And this is basically what the indictment said. And anybody wants a copy of that indictment, I'd be happy to share it with them.
Well, I think we're going to end it there. That was a lot of information to chew on. I really thank you for coming in and explaining that.
We haven't even scratched the tip of the iceberg.
Exactly. Well, just talking to you for the last 20, 30 minutes or so was overload for me. There's so much information here, and that's how it's been designed. The system has been designed to keep people stupid, to keep them dumbed down, and you put so many pieces of paper in front of, the normal guy, and he just wants to get his house. He wants to get in, he wants to close, he wants to get the keys, and he's not sure what he's signing, and then that paper just goes out the door, and who knows where it goes. It's been securitized, it's used to fund wars, it's used to do all kinds of stuff that it shouldn't be doing. So thanks for Dave Krieger coming in and educating us a little bit on these clouded titles out there, because that's information we do need to know.
We have a new white paper that's out now by the Government Accountability Institute that actually has gone into detail and is working, a working model, 27 pages long, that goes into detail about the MERS, Eric Holder, Lanny Brewer, DOJ, SEC connection.
Okay, well, let's explain most of the listeners understand this, but we got millions of listeners. So give us just a breakdown of what is happening, the history of this, and then give us the latest on the loving DOJ.
Well, the basis for writing the book was the fact that I started to see a pattern in 2006. I got out of my last mortgage in October rather, of 2006, right before it was going to reset itself. It was one of those adjustable rate mortgages. Basically, what was happening is in 2003, when this whole nonsense started, the promotion had been that everybody needed to, and this is part of the brain game, where they put this idea in your head that you need to own a house, and it doesn't matter, whether you have a job or not. That's why they have ninja loans, which is no job, no income, no assets. And they now have that for cars and everywhere else. Exactly, and you just tell us how much money you want to make, and we'll put it down, and we'll get you a loan for that. And they've got these programs out there that are all tied to the securitization market, and they use a vehicle called mortgage electronic registrations.
And then they tie these packages of total crud and get government to invest your pension and everything else in, and then holds you hostage.
Exactly. And then you find out your 401k's been depleted, and they're paying you back at 10 cents on the dollar after you sue them. So in essence, that's how this...
But they don't care because they got the fees swapping all the derivatives crud.
$50 trillion.
Plus the SWAT team standing by if you don't like it.
Yeah, it's $50 trillion they made off derivatives.
By the way, you don't add in here, you're a Vietnam veteran, combat veteran. Well, what is it like for you to see the country become this corrupt?
Well, from a Vietnam vet's point of view, it's sad that we have to see all of this stuff that we're over there. I mean, first off, most of the vets in Vietnam didn't even know why they were there. And most of the stuff I was involved with Army Security Agency, so I don't talk about that. So it's just one of these things where, as far as combat goes, we didn't see a lot of that. We were more behind the scenes.
You were more
advisory capacity.
More of an Air America capacity?
You got to love that. You run away with that one.
Loving government, huh?
Got to love it. Yeah, Air America, Black Ops, all the other good stuff. We know that there was a certain amount of that going on, but,
it's a very loving government.
Here to there,
It's a very loving government.
Yeah.
Here it is. Deed, who really owns your home? Over 700,000, or is that 70 million?
70 million.
Yeah, 70 million titles. I can read that. It's so big. To property are clouded. Is yours one of them? This book could help you find out and fix it. In fact, I use information similar to this book to make sure with my house that I had that. And it goes on to break it all down. Clouded Titles, new updated edition with case studies and sites. This is a short segment, long segment coming up. Break down how the scam worked, what happened, what Mirrors is, and then let's get into the usual suspect. I mean, it seems like everything. The Attorney General's involved in it, even back during Clinton with his law firm, when he was Deputy Attorney General, getting all this changed, where this is going. And then let's get into the Patriot mythology, getting a lot of people in trouble versus real stuff that's in your book. And then let's take phone calls.
Sure. Well, Alex, the thing started in 1995. It was a concept of how can we basically control and track and transfer these mortgage notes on Wall Street. And so Fannie Mae, Freddie Mac, the Mortgage Bankers Association, American Land Title Association, and all the major banks got together and came up with a game plan, and they got Covington and Burling, a law firm in Washington, D.C., to issue an opinion letter. And basically what it did was it gave what we call Mortgage Electronic Registration Systems, or MERS, credence to do what it's doing in America. And what, in essence, happens is that when you go to the closing table and you sign this piece of paper, which represents a mortgage or deed of trust, there's an 18-digit MIN number, or MERS identification number, that is the property of MERS Corp Holdings, Inc., that appears near the document title. And the things that we've been trying to do is to get people to recognize this, which is one of the fundamental reasons I wrote the book, because, you know, if you knew what the consequences were of getting a MERS loan or MERS mortgage, MERS doesn't have anything to do with the actual mortgage note itself. MERS actually only is a computer database that, for all intents and purposes, tracks the sales of these repetitively as they occur on Wall Street between the parties. The unfortunate thing about MERS, which it admits, by the way, is that it is not a substitute for the land records. All it is an electronic database that is used by its membership subscribers, which is kind of like the credit bureaus. If you ever wonder who inputs the data on the credit reports, well, this is all these member subscribers of the credit bureaus that have access to this information. And the credit bureau is entrusted through the Fair Credit Reporting Act to basically keep track and make sure that everything that's being reported is accurate, which is why we have the dispute process. You know, to look at just the opposite, MERS does not have this kind of government regulation, as do the banks. So it's not a real deed registration. They created it so they could run these scams and sell the deeds over and over again. Well, they sell the mortgage notes over and over again.
Exactly. So how many times? Exactly. But I mean, it's the same. I mean, the same thing in the final equation, though, isn't it?
Well, actually, no. Your mortgage note, it was really sad to hear that. I
mean, I know they're two different things, but they come back to court and try to take your house with it.
Exactly. Well, they try to come with part of the equation, not all of it. And this is one of the things that the attorneys who are studying this stuff and they're sharing this information with me are telling me, is that they're trying to get the entire equation put together and do it in such a way that the judge will believe it. Because right now...
So they're engaged in perjury and fraud, and constructive fraud. But the issue here is that for years now, they're getting their clocks cleaned in courts all over the place. And that's what you break down in your book.
A lot of them have been. We've had a few significant cases where the homeowners have won. And we just had a RICO-style action happen down in the Gulf Coast of Florida. We have an appellate attorney down there in Englewood that actually won a case. It's Elizabeth Corson, and you know, it's been circulating around the internet. And I'm sure if you type in Corson, C-O-U-R-S-E-N, you'll see that case. We actually defeated a motion to dismiss there on the appellate level. Basically, we reversed it. So, you know, we're having a few victories, and then, of course, we have some of the sad consequences of what happens to people when they go in and they try and fight this thing on their own, and they file documents in the land records that are not appropriate. And as I was sharing with you before we went on the air, Alex, this woman in California filed a document in the land records in an attempt to stop a foreclosure of her parents' home. And now she was convicted of 2 felony counts and sentenced to a year in jail.
Yeah, stay there. We're going to come back and break that down, because there are people out there on the internet that will tell you to do stuff like this. This is the power of common law. You're filing and swearing to something, and let me tell you, it's fraud if it's not true. Now, the banks are doing it, but just because they're engaged in fraud doesn't mean we now run to beat them and engage in fraud. So we're going to break down the right way to do it versus the wrong way and take your phone calls. Stay with us. But you see the cases on the news. I mean, we've played these here for like CNN, where they took in Florida a $1.2 million house that had been paid for a decade plus before with cash, never had securitized note that had been sold out in the market. Explain this to people, and let's get in, as you were, to the Patriot mythology. Some of the stuff where, declare yourself a sovereign of the realm of the Lord and file it, and then they'll just come arrest you. Because that's no different than what the bankers are doing. If they're engaged in fraud, you don't go file something else. You need to get this book, folks, because this has got a bunch of the cases that have actually succeeded, and there's different types of fraud going on. But please continue, Dave.
Alex, stuff changes all the time, and the scenario sometimes gets very ugly. We see cases like the one in Stanislaus County, California, where the woman is trying to protect her parents' house. It's in the final stages of foreclosure. And, you know, these well-meaning souls out there, I call them Patriot paralegals, type up these documents thinking that they can use the UCC, common law, and basically they move outside of the system's tools to attempt to enforce their way on the system.
And the system immediately recognizes that it's not within, you know, kosher systems.
Exactly, and this is what causes the problems. And as a result of her filing these documents in Stanislaus County, the district attorney had her prosecuted. We've had instances, numerous instances that I've run across in the state of Texas where somebody has gone in and written and filed affidavits after the trustee's deed. The property was foreclosed on, it was sold, the trustee's deed was filed, and so instead of fighting it at the detainer hearing, which would be the next thing, let's kick you out of your house, and so we have to go do what we call a forcible detainer hearing. And what ends up happening is this particular person files a whole series of documents, starting with an affidavit, rescinding everything that's already been foreclosed on. Well, it's a little late for that. And when she went to the county clerk to record it, there was somebody who didn't even work in the clerk's office that looked at the documentation and said, I don't think I'd file that stuff if I were you. She went ahead and did it anyway. And when I got to looking at it, I was just like scratching my head going, this is paralleling the case in Stanislaus County. A judge literally could throw the...
Well, I mean, there are a bunch of scammers. I know a bunch of Patriot paralegals who are winning in court and are having success, but they're following cases that have won. They're following, you know, systems that are there. So there is success there as well, but there's a bunch of lawyers. I mean, I've seen countless cases now that are having victories. The point is, you want to go with real instruments that point out the fraud the bankers are engaged in. Don't counter their fraud with your own made-up garbage.
Well, look at the county land records as a sacred vault of documents that basically represent a person's chain of title from the time they took possession of it and were given a warranty deed all the way up to the current state and condition of title. And through these chain of title assessment seminars and stuff that I do, I teach people to go in and analyze step by step from the warranty deed forward to see how many times the chain of title has been affected. One of the things we're seeing is the more you go out and borrow and refi and get a HELOC and refi, the worse condition the chain of title becomes, because you have more outside third parties interfering in the chain and filing documents that appear to be legitimate when they're anything but.
Well, let me ask you this. How bad does it get? Because I've had different economists and experts and lawyers on, some of the lawyers that have won in court that you mentioned in your book, and they talk about how many times in derivatives these securitized loans are being sold and the fraud that these groups are holding. How many times are they selling these titles on average?
Well, the notes are basically on Wall Street, Alex, are being taken and spun over anywhere from 9 to 30 times, maybe more. We don't know because they're hidden in the MERS system. The MERS electronic database keeps track of all the transfers, but none of these are recorded in the land records, and this is what's causing the problems with the 70 chains of title.
And they come take houses in some cases, not just where you're behind and then they fraudulently do it, where they just take houses that they never even had anything to.
Well, it could have been because of the fact that when they and I was talking to a title guy in Cleveland yesterday, and he told me that we see a lot of problems and mistakes that were done because somebody who was preparing the warranty deed put the wrong legal description on, and they basically, when they filed the warranty deed, all of a sudden it looked like that there could be a potential slander of someone else's title. And so when you're looking at a legal description that all of a sudden should say lot 6, block 7, but it says, because of the fact that, you know, they were having a bad day and looked cross-eyed at the computer, didn't have enough coffee, and hit lot 7, block 7, all of a sudden, now we have a lien on the wrong property. And this is where you see a lot of this back.
Oh, yeah, I saw cases, speaking of California, in L.A., they're now having thousands of cases a year of innocent people being arrested because they just put your name in a bank robber or a child molester's area, and now your life's ruined. And it's so it's so Byzantine that no one can fix it.
It's going to take at least a century to fix this problem if we can stop MERS now. And I do know that there is a movement afoot by many legislatures to try to cut the MERS equation out of the recordation process
But then what does that do to all the derivatives based on it worldwide?
Well, the derivatives generally don't have anything to do with what's in the land records. They're two distinct entities. But, I mean, you literally could go out if you wanted to, if it was available. You literally could bet against the weather. You could say, well, you know what? I know that it's going to rain tomorrow, but I'm going to bet against the fact it's going to rain, bet that it's going to be sunny, so that when it comes to find out that it's not sunny, I'm going to collect. I'm going to go in and I'm going to collect on that bet. This is kind of what they did when they structured these loans.
No, I know, but I mean, if MERS goes under, they'll lose even more of the cases. My point is, all this fraud is based on this fraudulent filing system. So, and from what I've read, the big banks are still doing this.
Yes, they are, and this is a thing that we have to, you know, the only thing I can do because I can't give you legal advice. I'm a paralegal. I'm not an attorney, but having looked at this from a journalist perspective, the only thing that we can do is say no to MERS mortgages. Just say, I'm sorry, but I'm not going to sign any mortgage paperwork if MERS is involved.
So anybody that's going to buy a house, anyone that's going to sell a house,
or refi,
or that already has a house with a mortgage, continuing, what are some of the other patriot mythology things? Because, I mean, people call me, they send me on air for 17 years, they send me these big stacks of legalese, and if I just announce this and that and file this, and I file magically bond money that's under my Social Security number will be sent to me, and, you know, I hear these talk show hosts, you know, they're going to file $1 billion lien on this or that, and of course, nothing ever really succeeds. But it's almost like magic. It's almost like, you know, thinking a Harry Potter book or a Ouija board is real. And again, Larry Becraft is a great lawyer and patriot. He's talked about this. There are real things to fight these crooks, and they are lawless. But again, just because the system's lawless, it still has the establishment mantle to it. And we're breaking through that. But you just don't fight it with whole cloth new theorem.
That's been a big problem, Alex. And when people go into the courthouse and take this system upon themselves and do what, you know, we're hearing about now, another horror story is these administrative processes that people are filing in the land records, and they're filing, you know, they're apparently trying to take something to the international court. And like the Hague doesn't care about this stuff. The problem that we're
don't you just, I mean, there are procedures to sue banks when they've lied, or isn't it where they violated the paperwork and violated your rights at the original time of signing? I mean, there's a lot of ways to go after them.
Well, you know, we've seen attorneys do non-disclosure suits because nobody was told that MERS was there at the time and what they were for. People went in and they were so interested in getting the keys, they just signed their life away. You literally could have put in there, borrower agrees to give us his firstborn 1 year after this loan, you know, is in force and effect. And they would just sign.
And a fraudulent contract is null and void.
Well, yeah, but they don't read it, and that's the problem. People do not read and understand what they're signing. They go to the closing table, they want the keys. You know, they've tried like the Dickens to get a loan mod, and why would you do a loan modification with a bank that doesn't even own your note? That's another big problem we're having. But
okay, well, just give us a smattering, because I've had a bunch of these lawyers on before, a smattering of things that are winning in court, things that are, things to, I mean, obviously it's all in the book, but things to look for.
Well, if you see documents filed in the land records, and we see most of the problems having to do with assignments, this is a big problem, because when they finally do come out of the closet, these people on Wall Street that are playing in the derivatives markets, and they record a document in the land records, generally we're seeing that it's 5 or 6 years past the actual date the note should have been conveyed into the pool. And this is a big problem. And the big arguments that are being won now is arguments having to do with whether or not this falls under Uniform Commercial Code at Section 3 or whether it falls under Sections 8 and 9. Because Sections 8 and 9, basically, for those unlearned, have to do with non-negotiable instruments. And so when I look at these situations and I see that a note has been taken out of the realm of an Article 3 UCC and put into Article 9 and has been pandered on Wall Street and sold and resold, and the borrower has no idea, then that in of itself creates issues that attorneys are litigating.
Also, they're successful, but I mean, I know you know all the finer details, but elaborate on this point and then the others that you're about to cover. What about where they have lawyers for the banks come in and lie and say that they have all the proof and chain of custody and ownership and all of this, and they're not? I mean, can't you also get them on that?
There have been movements in the states now, specifically New York and Nevada, Nevada came out with AB Assembly Bill 284, which basically says that if you file phony documents in a court case in that state, and it can be shown that these documents are not legitimate, that the attorney could be disbarred and be facing jail time. It's a felony.
Wasn't that already on the books?
It was just...
It's like saying pass laws.
Yeah, last year.
But it's like saying pass a law in Texas the TSA can't grab your genitals. There's already laws that you can't do that. I mean, there's got to be laws in all the states. I've seen some of them where you get in trouble for filing false documents.
Well, yes,
it's fraud.
There are
perjury.
Yeah, we have qui tam actions that have been filed all over the country, specifically in California.
Can't somebody do that who's not even a party? That's what that is, right?
Well, yeah, the qui tam basically is a whistleblower action, and they basically go out and say, okay, I declare that I have information, and based on that information, I'm filing a suit that all of these things are false claims. Those in and themselves are legal, but the attorneys I'm talking to that filed these claims years ago are now running into problems with them. And it all falls back on UCC Article 9 as to whether or not these are negotiable instruments under 3 or non-negotiable instruments under 9.
Most of the victories against the bankers, where is it successful?
Agency. The thing we're seeing now is if you can defeat and you can split or separate the relationship between the entities that are filing these documents and the entities that claim to hold the note, if you can split these things, in other words, when the trusts themselves come back in, and if you look in your assignment and you see an assignment that says this note has been assigned to, and there's some gobbledygook all the way through, formerly known as successor by merger to as trustee 4, and then you see a number like 2007-HE5 or anything like that, and a combination of numbers. You probably are dealing with a trust that has a pooling and servicing agreement, and this is what these attorneys like Mark Dan, the former Ohio AG, who's winning a lot of cases in Ohio, and he's going in and he's dissecting the pooling and servicing agreement and running it into court, and the judges, even though they're not focused on securitization per se, New York trust law has a foundation in these securitizations.
Well, I mean, the system has to write this or it will destroy confidence in everything.
Exactly. And people are starting to get a little disgusted with it, especially when they find out stuff.
A little disgusted.
Well, that's what I'm saying. Right now, we have to use a logical head, Alex. We can't go out and do some of the stuff that's going to get you thrown in jail. We've got to be reasonable with this, and we've got to take this thing, and there is a methodology to this, a method to the madness.
Now, what about, and we're going to go to break and come back and take calls, what about the system countering? I know they're trying to get some state laws passed to say mirrors is okay. I know they're trying to get the feds to have an agreement with attorney generals. I know that they're trying to kind of cobble over and paper over this. How is the system countering this? How are they trying to keep the scam going?
Well, the bigger picture is the lack of prosecution. That in of itself, when you don't put the bad boys in jail, the dirty work keeps going on. So, we come back to what we discussed first about Lanny and Eric and all the boys at the DOJ who used to be, basically partners with Covington and Burling, this law firm in D.C. that wrote the opinion letter for MERS. When you look at the bigger picture and you look at this 27-page white paper that was just released by Government Accountability Institute, they actually footnote all of the little causes of action that coulda, shoulda, woulda, but never happened because of the relationship between the DOJ, the SEC, and
But now, isn't that just the moral authority of the public waking up and juries and things that are involved, and the fact that now it's almost like a public tort warning that now they've been told stop doing this? Does that add any weight to stop them?
It does in certain jurisdictions. We notice that, like New York, for example, a lot of the judges in the 5 boroughs, like Arthur Schack, they won't put up with this stuff, and they know robo-signing when they see it. I virtually, if Arthur Schack would come to work for me, he'd probably be one of the best fraud spotters in the country.
Again, we go to robo-signing. That's been ruled.
It's still going on.
It's been ruled a fraud.
It's still going
and
on.
Obama's using a robot to sign now.
He has as a matter of fact, a robo-signer on his deed. His mortgage in Illinois.
But he's signing bills with a robot now, too.
He probably has a signing machine. A lot of them do. And they're using signing machines to sign the robo-sign.
Well, no, he'll be in Hawaii and just say, sign that bill. He shouldn't be able to do that.
Well, if it's not in front of a notary, go figure, because notaries require the president.
Yeah, it's all, look, I know what's going on here.
Sure.
The globalists are clouding all this so they can bring in a new system later they control and just go cashless and get rid of the old county deed systems. I'm telling you, they screw things up, tie all their fraud to everything, make it too big to fail, hold us hostage, and then roll out more tyranny as the solution.
They would like to put us on a national registry, but I think the states aren't buying it. That's the one thing, you know, remember.
Thank God for the founders. It's the separation of powers.
Exactly. And this is a problem when you're dealing with issues where the county land records have been there since time began in this country, and now you have an electronic data.
It's one of the few things that works great in government because it's ancient.
Exactly.
It's been figured out.
Exactly. And so when you have a system that comes in and is runs totally juxtaposed to what we know to be true and factual.
Yeah, we'll take our 1,000-year-old system. We don't want your little fancy dandy foreign banker flim-flam, you know, Bernie Madoff, Ken Lace, El Scamo system. We're going to come back with calls straight ahead. Amazing, and I mean amazing interview. Clouded Titles, Dave Krieger. Okay, we're taking your phone calls here, talking about the giant fraud. And before you leave, because you started getting into it, but we never got into it, before you leave, get into the Justice Department and our loving Attorney General, because he's a big part of this. Well, being a good fellow from Chicago, we're going to get to it.
I understand. Well, you know, basically the word that's out on the street now through some of the reports that we're seeing, and we review these things on a daily basis. We're looking at issues between the DOJ and Covington and Burling, namely that the Eric Holder, Lanny Brewer were employees or partners, if you will, of Covington and Burling, which issued the opinion letter for MERS and MERS Corp. So when you have the DOJ tied to the entity that the banks basically use to transfer all their notes on Wall Street and play in the derivatives markets, you have some real issues.
Well, no, that's the word. I mean, you get the select groups, the law firms, the accounting firms, Arthur Anderson, and then you can do whatever you want. People ask, well, how can Mitt Romney not pay hardly any taxes? Well, he's part of the special club. And that's how the payoffs work. Let's go to some phone calls. Jim in West Virginia, you're on the air with our guest. Welcome, sir. Go ahead.
Thank you. Well, two things utterly amaze me at their insanity. You can make every payment, but you never get the wet copy after you make all the payments of the note, so it still isn't yours. And the banks collect and or foreclose based on a worthless copy of the original valuable note. Now, judges know the difference between a note and its copy. The copy is a forgery, for crying out loud, just like there's a difference between a Federal Reserve note and a Xerox copy of the currency. Can you comment on this criminal insanity on the part of the judges? And I'll just listen.
Well, the biggest part of the problem that we're seeing now is, you know, when people bring stuff into court, the judges basically buy what evidence has been presented that hasn't been objected to. The bigger problem we're running into is a lot of people that go in there that get out-procedured by the banks, and I think this is where the largest part of what we're seeing is the problem. You know, not that, you know, pro se litigation hasn't won. We had a case, Reed versus Fannie Mae in California, that just came out where she got a summary judgment. But
to be clear, if no one objects, they could go in there basically with the back of a Cracker Jack box and say, here's my proof.
Yep, bring anything they want. And the court will accept it as long as you don't object to it. This is the general game plan. And a lot of people do not understand when they go into court that you can literally get out-procedured because these people have a specific game plan. We have networks across the country of foreclosure mills that all band together and share information in a big way. And I talk about that in the book. And so when you see all of this
information, it's called organized crime.
Well, you call it what you want, but the fact of the matter is it's network sharing. And this is what we're trying to do on our end, is we're coming back and we have a network of about 40 attorneys that have all banded together and share information, and this network is growing. And there are significant players in this thing that are actually winning cases.
Now, like you said, former attorney generals of states and people like that. Thank you so much, caller. We're going to go to break and come back with more as we got to go to break.
Hey, what's going on, guys? Thanks for taking my call.
Thank you.
Hey, I got a question for you. I don't know about these reverse mortgages. I'm hearing them air a lot on commercials, and it looks like they're attacking a lot of senior citizens. So if you guys can elaborate on that, something to look out for your mom or whatever.
Yeah, that's a great question. You know, they're telling old folks, live in your house till you die, but get some money to live now on the house. In a way, maybe that's a good idea because the IRS will try to steal old people's houses unless it's all clouded, but I'm not giving advice. I mean, I'm sure that's probably pretty predatory. What's going on?
Well, reverse mortgages, and we had a question on that on another program that I was on, and the woman basically was concerned about the fact, as you stated, Alex, that she was wondering whether or not this was a smart move for somebody that's getting up in years. And normally when I think of people going into retirement, I'm thinking of people that are trying to literally pay off their mortgage and find a passive income stream. But because of the fact that America's financial education, well, you obviously didn't learn it in high school, you actually have to, instead of the school of of high school. You learn it in Fort Knox or Hard Knocks, so to speak. You basically learn because you've sacrificed your almighty dollars and have gotten nothing in return. The bigger problem we're having is that the lack of education, lack of financial education in this country has basically allowed the lending community to prey on the interest of these people, and so they get these famous movie stars on that look trusting, and they recommend these things and recommend these.
So you're saying it's a bad idea?
If it was my situation, I was facing retirement, I sure would be looking at another income stream. I could think of a lot of other things to invest in.
Sure, but let's say your cancer's in remission, you think you're going to be dead in 5 years, do the reverse mortgage, go to the Caribbean, have a good time. Part
of the problem is, though, your estate starts to diminish, and pretty soon, by the time all this is said and done, your estate is left with nothing. I mean, that's the...
But, I mean, yeah, if you don't want to give your kids the money, though, blow it. I mean, it sounds bad. I'm not saying reverse mortgages are good. I don't know much about them. I'm just saying, are they always bad in your view?
I generally tend to shy away from them, but, people have the reasons for doing it. And I always tell them, look, if you're going to do a reverse mortgage, the best thing to do is consult with a financial professional. Get it
well, yeah, why not sell the nicer house and move into a smaller apartment in a retirement community instead of getting the reverse mortgage?
My mom did that very thing. She did the very same thing. She took her... all the money that she had, she sold her house, and of course, her being in Florida, she took a nosedive on that house and lost $100,000 when she sold it. And so she took that money and put it into annuities and what she considered safe investments and left it there. And so then she moved into an apartment. And that way, when it's time to settle the estate, everything is very easy and not complicated. Now, the average person could have said, the reverse mortgage sounds good because I want to leave something to my kids. Well, the downside of the reverse mortgage is the fact that it depletes the estate. So if the intent was to leave them something, well, don't you think it would be better just to try to figure out a way to create an income stream to pay off the mortgage, or figure out a way to, rent the house out and move into an apartment so somebody else can pay that mortgage? Because that's what a lot of people do when they can't afford the house. They rent it to somebody else, and somebody else makes the mortgage payment, and then they move into an apartment, which is cheaper, that they can live on, and they're fixing.
All right, great analysis. I think that answered his question. We're going to go to break. 2 more segments. The next one's long.
Yeah, hi. Dave, there's another 500-pound gorilla out there that's clouding title. That's the IRS. I was in a urinating contest with him for many years, and I finally had to go through bankruptcy to get him off my back, but I'm still saddled with a big lien on my house that my bankruptcy attorney says I'm stuck with it. There's nothing they can do about it. But what the IRS does is they don't go through the normal procedure that anyone else would have to go through to file a lien with the county recorder. The recorder just says, well, we just file anything as long as the appropriate fee is paid. There's no certification, to be specific.
Is that even a mechanics lien?
No, they have to certify that the information in there is accurate, and they don't do that. It's robo-signed by someone who doesn't even exist.
Yeah, no, I'm familiar with that. And by the way, this is the big scandal. You saw, Dave, this big breaking news, just to add a caveat, and I'm going to get the article out soon. For 3 years, I've been talking to a senior IRS person, and then for over a year another. But the last few months are like, listen, there's going to be a big thing. We're told to give people fake, well, I mean, they're not fake, but they really are fake, under wrong names, these tax IDs. Then they can then attach those to Social Security numbers that aren't even the same. And government, Texas Comptroller, others have released millions of them. Foreign governments are involved, you name it. It's shutting down the IRS. But it's worse. When the illegals do stuff in your name or whatever, the IRS, and there's this identity fraud involved, will come and still take your account or put liens on you, and they're told it doesn't matter, just use it to take their money. And the IRS is finally in a mutiny. The biggest center in the country is here in Austin. They are finally just going, we can't do this. And they're taking retirees' homes, you name it. I mean, it is. So this breaking news you see is really a whitewash is what I'm saying. But what do you say to that, Mike?
Well, my question is, isn't there a way, can I do a quiet title action? I couldn't get any attorney to touch it locally here.
Yeah, how do you challenge the fact that it's a robo-signed fraud?
Well, again, you're dealing, UCC largely in part deals, from my understanding, in Article 9 which is basically possession is 9/10 of the law, and if they can go in and seize whatever's in your bank account, and I know that, judging from what I've talked to attorneys about, Mike, on these issues, that they're telling me that certain bankruptcy debts are dischargeable. Or IRS liens, rather, are dischargeable in bankruptcy if they're older than 3 years. My CPA even confirmed that. But, the fact of the matter is that, once liens are there, there are certain procedures that you need to find a real estate attorney that understands this stuff, that can go in.
Yeah, there are people that aren't cowards that are willing to go up against the IRS.
There are attorneys that will go and challenge the existing liens on there, especially if a lien has been discharged in bankruptcy and it still is, showing on your chain.
So what saved you? Your homesteads saved you from their clutches?
Well, it's the bankruptcy itself stops any collection activity, but that doesn't make the lien just go
By the way,
away.
Mike is a doctor, and he hadn't called in a few years. But you've been listening over a decade, haven't you, Mike?
Oh yeah, since the early days.
I recognize your voice. How you doing?
Oh, not too bad. Unfortunately, the old saying that a fish rots from the head down. Our administration here at my little hospital seems to have the same infection that the feds have, that they can just do pretty much whatever they want, and this mentality seems to be permeating our entire society.
Yeah, the more Americans go along to orders, the tyrants will gravitate to the positions. Thomas Jefferson said the level of tyranny you will live under is the exact point you will put up with. And that's the bad prognosis, Doc, as you know. But I tell you, you've been listening, it's got to be 12, 13 years. Has it not all come true like we said? I mean, we're just following the signpost right into hell here. I mean, we're getting pretty close to the mouth of the furnace now.
Yeah, well, like you, I've known for a long time what was going on. I'm old enough that I thought, well, this is something that the next generation is going to have to deal with, and I never dreamed that, at fast approaching 60 years of age, I'm going to be the one that has to deal with it.
Well, look out, because my IRS source said 70+% of the audits and seizures are doing, they've been told target retirees, and they've changed the laws retroactively to now try to get your money and say, oh, you took $200,000 out the last couple of years out of your retirement. There's penalties and interest. You owe us $1 million. And it's not even a law. It's just total criminality. Good to hear from you. Any other comments on that?
I'm good there.
Amazing info. Let's talk to Nathan in Minnesota. You're on the air with our guest.
Hi there. Thanks for having me on. I'm actually a friend of Dan Feitz, who's been on your show before.
Yeah, good guy.
I'm an attorney here in Minnesota, and I practice in the area of bankruptcy, and then I've studied this issue. I've had some knowledge and exposure to this. Just a couple of things I wanted to say. In Minnesota, that MERS has come and lobbied our legislature and just gotten a MERS statute that just says everything they have done is okay. And they also got a favorable decision on a certified question from the federal court to the Minnesota Supreme Court in the case of Jackson v. MERS that basically says, yeah, everything they do is fine. You can sever the note from the lien. That said, I think people should be really careful about, what attorneys they hire. We just had one here that got sanctioned for a lot of money and who was representing to people that he was going to be able to take care of these things. So be real careful and check into who you hire. And then the other thing I wanted to say that has to go with the IRS, you see the IRS picking on little people all the time. When these things were securitized and they put them in like these REMIC trusts, I've learned this, I've gone to continuing legal educations on this from real legitimate attorneys that have been involved in this, a lot of people from the South. They put them in these REMIC trusts. It's my understanding from these attorneys that the nature of these trusts is such that you're not supposed to transfer these assets around once you've got them in these trusts. So essentially, it appears to be that there's massive tax fraud that has been perpetrated by these banks and maybe Goldman Sachs or whoever's been churning these things out. I actually got to talk to a retired partner in Goldman Sachs at a bar, kind of a friend of an uncle, who basically, he designed these things, and he basically acknowledged to me off the record it's just a big fraud, that they would have them certified AAA and spin them off. And so I think that there's massive. You see our little, our doctors, that's an upper middle class person, but I see people, truck drivers and stuff, picked on by the IRS.
Oh, no. They admit they go after little people for no reason because they can't defend themselves. I mean, it not only is the IRS robbing people, folks, you're robbing innocent people and destroying families. Your mojo, whatever you want to call it, your karma, your reap what you sow. I wouldn't want to be you. And I'm not talking about people doing something to you. I'm talking about God. I mean, I've learned one thing, folks. You do wrong, it comes back on you many-fold. I notice, Dave, that you're sitting there pretty excited to say something you know about these cases. Thank you for the call, sir.
I have one question.
Stay there, stay there.
Yeah, I have one question I want to ask Nathan if you're still in the...
He already dropped, sorry.
I'm trying to find out how much luck these bankruptcy attorneys are having doing adversarial proceedings inside of Chapter 13, because a lot of people, they try to do a Chapter 7 bankruptcy, and you basically are just discharging and dumping all the debt.
But you were nodding your head when you talked about a lawyer getting sanctioned in Minnesota.
That was a massive case, and he's still getting sanctioned. He basically was doing a lot of blanket filing of the same type of lawsuits trying to stop these foreclosures, and the courts basically just hammered him. Unfortunately, the problem in Minnesota, and this is, there are several states that are really seriously in trouble. Michigan is one, Minnesota's one. They've given MERS a lot of latitude. Arizona, with the Cervantes case and the multi-district litigation, has given MERS a huge...
So the courts are backing the fraud.
A lot of what we're seeing is that the courts are siding with MERS in that... and this is part of the problem is the borrower. The borrower went in ignorantly and signed his name to a deed of trust or mortgage and gave MERS...
But a fraudulent, I'm no lawyer, but I know in all law, ancient and the more newer forms, something designed to deceive and to be a fraud is a null and void contract.
If it can be proven. The thing I have to ask the borrower when they go to the closing table, like yourself, when you went out and got a mortgage loan, did you read before you signed?
Yes, but it's written in legalese, basically in a foreign language.
I understand. Did they tell you that you could get an attorney at the time that you signed this document? No. Yeah. See, the thing is that Americans, because of this lack of financial education I was referring to earlier in the show, because of the fact that they...
No, we've been raised to be victims and to be cattle. That's why the big banking associations 100 years ago or more said we've got to finance the dumbing down.
Yeah, well, you have to look at, when you go in to sign a mortgage loan, if anything, if you know somebody that's going to be buying a house at any point in time in the near future, you need to sit down, if you know about this book, and you need to share it with them and tell them, look, if you go in and you see an 18-digit MIN number, it means that they intended to securitize your loan. That MIN number was on your document before you went to closing. They already had that note and that pool and everything.
No, they already get it agreed to get you the loan. Now, and they shop it around. That's how they get it. But to expand on that, you're saying more and more, you can go to title companies and others themselves. You can do an original old-fashioned system. You've just got to ask for it, right?
There are good banks out there that will hold the paper, and that's the way it used to be.
Kind of a question and a comment. Well, actually, I was helping a friend of mine who's been facing foreclosure. She's been fighting successfully through an attorney, but then they dropped her because the banks wanted to do a modification, and she didn't. So we went pro se because we couldn't find any attorneys to help us. One actually said, you know what happens when people come against the system? They get killed. So we went and we showed the judge that the assignment of mortgage was done 2 months after they had already first filed for foreclosure. So when she talked to the attorney said, oh, that we took care of that before. And she said, no, there's nothing in here about that. And then she said, you have the original? He said, no. Finally, she looked at him and she goes, you got a serious problem here. And she says, but I'm not dismissing the case. And she looked at my friend. She goes, because I'm not going to give you a place for free. So they stopped it. They didn't give them the summary judgment. So listening to you, I've written down some notes. She did get an attorney because when my friend said to the judge, we feel there's fraud involved in the actual...
Sure, we're not going to be able to break down the whole case here today, ma'am, or give you, things that are going to win. You need to get the book or do further research. But do you have a question for our guest?
Well, yeah, the question is that they want to do mediation. Should we bring up... They're supposed to have a title expert. So if he's there, should we bring up the whole thing about what you were mentioning about the...
Well, ma'am, we can't sit here and give you advice over the air and know the particulars, but I appreciate your call. But I'm sure you hear this all day, Dave.
I do a lot. And, basically the way things are, if I was in that position, Alex, I would be, looking at the attorney and I'd be saying, okay, what's wrong with the logistics here and why aren't we arguing these things? I mean, he needs to speak up. My biggest concern, because she was sitting there talking about a loan mod, if you've got a document or an assignment that is questionable, and it's questionable, then the question then becomes, or the issue becomes, why am I negotiating and doing a loan mod with a lender that may not own my note?
Yeah, but that shows you've already gotten pretty far that now they're trying to...
Well, see, the problem with loan mods is it drives the borrower because it takes a long time to get a loan mod done, and the whole time that this is happening, the borrower is either making trial payments or not making payments at all, and they're getting deeper in debt, and there's more servicing fees being added on by the servicer, and so as an end result, it costs more to dig out of the snowdrift, once everything is all piled up around you. So, this is why we go back to the core and look at chain of title versus chain of custody of the note.
Exactly. They're trying to change the subject. Let's go to Bob in Florida. Bob, you're on the air.
Hi, how you doing?
Good.
Listen, it's funny that you guys are bringing this up today. I had a piece of property that was sold yesterday, and I got a phone call from the title company, and here the notary at the county level never had a witness when she notarized it. Now she's a county employee, never had it witnessed, and here the title company will now or will not allow the sale to go through, and I was told I have to go get an attorney.
Well, that's one of the good things now. They're starting to make them not do all the robo behavior. Go ahead.
No, that's a valid argument and a valid reason to go get counsel because of the fact that, somebody might be subtly sending you a message that you might have an out here. You might be able to vacate the entire judgment and sale because of the fact of the way the case was done. And that's, when you're seeing any little thing that's wrong, including not having a notary witness or any number of little factors that creep into this situation.
Yeah, what's happening is you've got moral people who thought that the IRS and other places were legitimate. Now they're finding out it's all a fraud. Got people at the county level, they're not allowed to come out and speak out against it because of the tyranny, but they will sit there and give you tips. They will, explain things to you.
Well, they can't give legal advice either, Alex, but they can drop subtle hints, and that's apparently what this gentleman has happened to him. And so if somebody says, I really think you need to get an attorney because I see a problem here, they're basically speaking off the cuff to you, but what they're doing is they're dropping a subtle hint that you may have a case. And you always have to entertain that. You can't, for you to sit there and do nothing diminishes your chances exponentially.
And the more of us fight them just by sheer numbers, it's gonna drive this out in the open. Great call, sir. Does that answer your question?
Yeah, the only other question is, do you have any recourse, because now I have to get an attorney to deal with something that the county was supposed to do.
Okay, real fast. We're almost out of time. Sure.
Okay,
you'll find out more in the book, Clouded Titles, InfoWarsShop.com. It's a complex issue. All right, Dave Krieger, great job. Thank you for coming in.